So when we're looking at hours, we've got four main things to consider. We've got regulation of the maximum hours that people can do in a week. We've got regulation of the breaks that people are entitled to take. And spoiler alert, it's only 20 minutes for each 6 hours. We've got some provisions on how all these rights are enforced. And then we've got the topic of 0 hours contracts, or put in a more positive way, whether or not people in Britain are going to get a right to regular hours. So let's start with some data. The UK has pretty long working hours compared to most other countries in Europe. So this chart shows the average number of usual hours worked by employees in 2019. And this is the last year where we've really got comparable data for the UK to the European Union. Since then, data collection has been a little bit more complicated because there are slightly different standards, and so 2019 is the latest year. But what we can see is that the UK has pretty long working hours. So far as Western or Northern European countries go, it has some of the longest working hours, and it is much closer to Eastern European countries in the length of the working week. So, that's a significant problem, because Britain is, at least on paper, quite rich in terms of GDP, but the productivity of British workers is pretty low, and part of that has to do with long hours culture. So regulating working hours and making sure that productivity output per hour goes up would be assisted a great deal by getting working time down, and particularly pointless working time where people just sit in an office not doing very much, waiting out the rest of the day. Okay, so working hours are pretty long in the UK, and part of the reason for that is still because of the lack of proper regulation to get working hours down. So what do we have? Well, under the Working Time Directive, Article 6 says that the average working time for each 7-day period, including overtime, should not exceed, or there's a right that it does not exceed, 48 hours. However, there's a series of exceptions under Article 17 for managing executives of companies who are deemed to be able to set their own working time, to have more autonomy, for people who are family workers or people who are religious workers. But then the big thing that goes on top of these sort of explicit exceptions is that Article 22 of the directive, through heavy lobbying by the United Kingdom, before the directive was passed, created the right to have an individual opt-out. So it's possible for member states to allow workers to sign a piece of paper saying, I opt out of the 48-hour working week limit. And by the way, if we think about this for just a second, a 48-hour working week is already incredibly long. So that's actual working time, and you've got to add on to that lunchtime, transport, to and from work. The average working weeks that we saw before are somewhere under 40 hours, 37 and a half is often a typical working week. So, this maximum limit of 48 hours is not actually catching that many people. But it is incredibly important, because if at the extreme ends people are being dragged into a longer hours culture, then that can have a magnetic effect on other people in the workforce. Okay, so the way that the UK implemented this in the working time regulations of 1998, and I should say there was a previous directive before the 2003 directive, which is why the UK regulations predate the directive, but it's still the same thing. Regulation 5 says you've got to have the opt-out in writing, and there's some other provisions in the Employment Rights Act 1996, Section 45A and 101A, which ensures that people have a right to not be subjected to detriment if they refuse to sign the individual opt-out. Okay, so that was meant to be the sort of compromise, that people shouldn't be forced into opting out of the 48-hour working week limit. You've got to sign an agreement. But the reality is there's an expectation in many workplaces that people will just opt out anyway. And there are a lot of workplaces, law firms often are a common culprit, that have very long work weeks and don't even bother to ask their employees whether they want to sign an opt-out form. It is just expected, and there's a lot of peer pressure to not complain about the incredibly long hours culture. There's another workplace where there is often a very long hours culture, and that's hospitals with junior doctors. So think about people working in A&E, and there's different rules for them. So under regulations 20 and 25A, junior doctors have have a 52-hour working week limit, so significantly higher. And as we're about to see, this drove a lot of the case law. You've got to have an individual opt-out, however. It can't be an opt-out through a collective agreement from the 48-hour working week. So we see this in Pfeiffer and Deutsches, it should be Deutsches Rotes Kreuz, so the German Red Cross. Here you had some ambulance workers, and they had a collective agreement which said that the working week limit was 49 hours. That's just 1 hour above. And it was held by the Grand Chamber of the Court of Justice that this collective agreement violated the directive because it had to be an individual opt-out. You can't have a collective agreement doing the opt-out. It's got to be individual consent. And there's also another important point about interpretation in Pfeiffer that the Court of Justice uses. It says that if you've got an exception to a rule, then the exception has to be construed narrowly. So more cases on junior doctors are seen in Spain and Germany. So in SIMAP, you have the Spanish Doctors Union, which claims that the health ministry was breaching the directive by excluding doctors without scope. So there you've got doctors, like in many countries, working very long shifts. Some of the evidence showed that some doctors were having to work 31 hours without proper breaks. And the doctors were claiming that the time that they had to be physically in the hospital but were on call to respond to emergencies, known as on-call time, should be counted as part of working time. The Court of Justice held that that was true. On-call time was working time if the doctor's presence is required. And so think back also to wage regulation and the national minimum wage. You've got the same problem about whether if sleeping facilities are provided, if you've got to be there, then should you be paid the national minimum wage? So here you've got the same issue, and the Court of Justice very straightforwardly says if you have to be there, if your presence is required, then that time, even if you aren't working at every single moment, time that you are on call counts as working time, and therefore that goes to calculating whether the maximum working week has been breached or not. Similar case in Germany, although despite SIMAP, the German hospitals and German employers had not changed. It's called Jäger. So Dr. Jäger, which means Dr. Hunter, think of Jägermeister, and it's like hunting masters, so Dr. Jäger is Dr. Hunter. He's a surgeon, and he claims that on-call time was working time. The collective agreement that covered his workplace said that time doing work tasks should not reach 50% of on-call time. So if it was under 50%, then it didn't count to working time. He had a room, the on-call time, I should say, that where he wasn't working didn't count. He had a room and a bed to sleep on at the hospital. Okay, great. But the problem in SIMAP that is alluded to is still present here, which is that his presence is being required at the hospital. Court of Justice holds that on-call time, again, was working time, despite the majority academic opinion in German commentaries, usually not terribly supportive of workers' interests, was saying that on-call time is not working time. Court of Justice held it was. But one of the unfortunate effects of this was that because the directive, largely through UK lobbying, was so full of holes, what a lot of countries did after Jäger and SIMAP was that they created express opt-outs, or rather express derogations for doctors in their national law rules, as was allowed under the directive. So, long hours culture is an incredibly difficult thing to tackle, but specifically in industries like medical care, where there's often a shortage of qualified staff, and people are incredibly overworked, and long hours culture persists. Very difficult problem to tackle, but simply ignoring the problem is probably not the best way of doing it, although that's what a lot of member states have in fact done since. Next topic is breaks and night work. So Article 3 of the directive, which becomes Regulation 10 of the UK Working Time Regulations, says that in a 24-hour period, you've got to have at least 11 consecutive hours of rest. Okay, so you can't work so much that you don't have at least 11 hours off at a time. And of course, this works together with the 48-hour work week maximum, subject to the problems over opt-outs. You've also got to have within a week at least a 24-hour period of rest. So we're very far away here from a 2-day weekend. It's just got to be 1 day. And Article 5 turns into Regulation 11 in the UK. And then for breaks, the rule is that you've got to have at least 20 minutes of break if you work for a 6-hour period. So that's not particularly generous, but that's what we've got as the minimum standards. And Regulation 24 also says that you've got to have a compensatory period of rest if your break is interrupted. And we see that illustrated in Hughes and Corps of Commissioners Management Limited. So here you had a security guard who was working in Croydon for Orange, and he was allowed to start his break again if he got interrupted by some emergency, some security issue. He could start his break over again. But poor old Mr. Hughes was interrupted so often that he decided that he would bring a claim because all he wanted was an uninterrupted break, and he wanted to be guaranteed that right. However, the Court of Appeal holds that there's no right to be guaranteed an uninterrupted break period. It's enough that you get to restart your break once if there has been an interruption, and you deal with that in the way that is needed. Then we've got Articles 2, 8 and 13 of the Working Time Directive, which become Regulations 2, 6 and 7 that deal with night work. So this sets a limit to the amount of the working day that people can have when they do night work. So the nighttime period, or the sort of core protected period, if you like, is from midnight until 5 a.m. And if you have a shift that goes over these hours, then the maximum that you can do is a period of 8 hours in any 24-hour period. And there's also an 8-hour maximum period if the work that you are doing is hazardous. So that's the regulation that we've got on night work. Now, how does any of this get enforced? Obviously, you can go to court, but if you're an individual, you often are going to find the court proceedings complicated. It costs a lot of money to get legal representation. So what you really want is you want to have a union in your workplace. You want to be a member of a union that can bring issues up without going to court and all the expense and time that entails. So unions are the main line of enforcement for working time rules to make sure that the employer's practices not only comply with the law, but also ideally reach up to higher standards that are set down in a collective agreement. We're also getting a new body called the Fair Work Agency in the United Kingdom. But although it's going to have jurisdiction over offences in the working time regulations, it's not on the current drafting of the bill going to have any jurisdiction on enforcement of non-criminal offences, or I should say, non-criminal statutory violations. So it's not going to have jurisdiction over enforcement of holiday pay. And we found out that the person being appointed to the Fair Work Agency had previously been an advocate of rolled up holiday pay. That's a man called Matthew Taylor. So this doesn't look incredibly good from a pro-worker perspective. Then we've got a question of what remedies the courts could enforce working time rules if it does get to court. And the Barber case is an unfortunate illustration of courts not being prepared to enforce rules fully. So what happens in Barber is that Mr. Barber and other people who were pit deputies claimed an injunction that they should have to work no more than 48 hours, and they did this while a trade dispute was going on. They had refused to opt out of the limit to working time. RJB Mining, their employer, argued that they only had to take reasonable steps to comply with the duty to keep within the 48-hour work week, and the High Court sided with the employers. They issued a declaration that the workers were entitled to refuse to work over 48 hours, but they declined to give an injunction, as this might interfere, it said, with the trade dispute. Now, I say that this is unfortunate because, very simply, if you've got a right, then the court should be able to issue an injunction for compliance with the right. You could interpret this case as being solely related to a trade dispute, and therefore you've got a right to get an injunction for an employer to comply with the working time limits if it's outside the context of a trade dispute. And there's some authority to this effect. For instance, in Edwards and Chesterfield, the Supreme Court says that you get an injunction for an employer to comply with terms of the contract. By extension, you could say, well, this is authority for saying you could get an injunction for an employer to comply with statutory rights. But on the facts, the injunction is not issued here because of a trade dispute. And that just shows some of the complications and limits of courts. What you really want is good faith working relations and a collective agreement with union, cooperating with management to get decent standards for working time without a dispute breaking up. Finally, we've got a right to regular hours. So this is outside of the Working Time Directive, and it's mainly to do at the moment, or until the Employment Rights Act comes into force. It's mainly to do with common law. So a 0 hours contract is an enormous social problem, and it's where an employer reserves the right to itself to say that they have discretion in the employment contract to vary a worker's hours, potentially wherever it likes, but potentially down to 0, and usually without giving any reason. So there is usually no right in a contract to any fixed set of hours. So if the employment contract doesn't say what your hours are, it's just silent, then you fall back on the implied terms, and the employer might expressly reserve itself the right to vary a worker's hours. And so this is what we call a 0 hours contract. Working hours can be varied at the employer's discretion down to 0. So if we just look for a second at other areas of law where discretion of a more powerful party is regulated, we can see that in the Consumer Rights Act, Schedule 2, paragraph 11, says that a business cannot unilaterally vary terms in consumer contracts without a valid reason, or it can't vary the content of consumer contracts without a valid reason. And very simply, there's no reason why we couldn't put something similar into employment rights legislation, but we haven't got there yet. Another way in which this issue is regulated in other countries, notably Germany, is it's said what hours will apply as a default if nothing's set down in the contract. The German Part-Time and Fixed-Term Act of 2000 says that there is a 20-hour work week as a default if nothing is said explicitly in the contract. And that incentivizes the employer and the worker to say what the hours should be. Now, if the employer does set the hours, or rather when the hours are set in the contract, that there's also a limit on the discretion that the employer has to vary hours. So it can vary hours up by a maximum of 25 and it can vary hours down by a maximum of 20%. And that ensures that workers have some kind of security about what their working time will be, and therefore they're going to be able to get paid enough to afford the rent, the bills, and whatever else they need to pay for. This is a basic issue of income security. But we don't have any credible regulation yet. And zero-hours contracts in the UK have exploded, particularly since 2013, when, under the Conservative Liberal Democrat coalition government at the time, job centres were told that they had to make people take 0 hours contracts as a condition for getting job seekers allowance. So before then, if employers said, we're not going to guarantee you any hours, a job seeker was perfectly entitled to say, well, if you can't guarantee me any hours, then I can't take the job. But after that, because of the government, people could be pushed into 0 hours jobs, and they exploded. So up to something like, well over 1 million people are on 0 hours contracts in Britain today, 1.1 million people in 2024. And this means that there's a huge number of people who are very precarious, who don't know what pay they're going to get because they don't know what hours they're going to get, therefore paying the rent, paying the bills, looking after a family. Is very, very worrying, creates a huge amount of anxiety, and it's a social problem that we don't need to have if the law was active in tackling it. It is possible that a worker could go to court and succeed in arguing that when an employer has a 0 hours contract, it's not the true bargain, so using reasoning like in AutoCleanse. And this is seen in Borrow and Cardinal Security, where Mr. Borrow's contract says your working hours will be specified by your line manager. Okay, so reserving discretion to the line manager to vary Mr. Borrow's hours potentially down to 0. In fact, he worked a typical shift of 48 hours for 4 years. Then he had a falling out with a manager, and he was told after being relocated that his hours were being unilaterally reduced. He objected. He said he was told, well, you just got a 0 hours contract, so there's nothing that you can do. He went to court and he claimed unfair dismissal, and Justice Supperstone agreed that the discretion in the contract did not represent the true agreement, taking into account the parties' relative bargaining power. So he applies the reasoning in AutoCleanse and Belcher from the Supreme Court, and Mr. Borrow wins his claim. But he was lucky, and not everybody can go to court and win. And particularly when you're in a precarious position, you're on a low income, you've got uncertain hours, it's going to seem very, very daunting to try and go to court and fight a case. And it might take years, and you might not get anywhere. So what really needs to happen is there needs to be regulation. And regulation was promised by the Labour Party, now in government, in a document called the New Deal for Working People a few years ago, 2022, I think. It said Labour will ban 0 hours contracts and contracts without a minimum number of guaranteed hours. However, in the run-up to the 24 election, a new document called Make Work Pay rolled back. So it said Labour will end one-sided flexibility, ensure all jobs have a baseline level of security and predictability, and then it says it would be banning exploitative 0 hours contracts. Very different, of course, to saying banning all 0 hours contracts. But then it's gone back even further because in the proposals in the Employment Rights Bill, on the draft that we've got currently, which is, as I speak, being stalled in the House of Lords, it says that employers have to offer workers a guaranteed hours contract at periodic intervals, but we don't know when because that is left to further regulations, rules that have to be made by the government minister. And workers are also going to get a right to notice of changes. But this means that we're not going to know what rights people actually have until the regulations are written, and we don't have any idea, or we haven't been given any indication about when regulations are actually going to be written at all. And further, Section 27BV suggests that there might be regulations written to exempt employment agency staff, who are some of the most vulnerable people. And when you look at who's got 0 hours contracts among that 1.1 million, quite a lot of them will be be people who work through agencies. So there's been intense lobbying to try and make sure that the rules are not changed and that any reform is emptied of any meaningful content. And the much simpler thing to do would be to get rid of these incredibly complicated rules that have been written into the Employment Rights Bill and just copy what already happens in another member state of the European Union, like Germany, and have a maximum variation of hours after a default set into the law. Okay, so next thing that we're going to talk about is childcare and flexible work.